May I please, Your Lordship? This is for listing of a criminal appeal.
Criminal appeal for
For
orders.
For hearing. For hearing.
Make an application before the registry for hearing. No auto turn hearing. Yes.
Lordships, I beg to mention item number 12, wherein we have filed the appeal in opposition, Lordship, today. Is the copy. Let the matter be taken up along with.
Lordship, I have received the copy. I have received the copy.
Okay. It's not in the record.
Not in the record, Lordship.
Okay. Heard Mr.
KJN.
N. Chaudhary on behalf of Dr. N. Deka.
N. Chaudhary, Learned Counsel, representing Dr. N. Deka, Learned Counsel for the appellant, and Mr.
KJN.
A. Jain, Learned Counsel for the respondent. So it is submitted by Mr. Jain, Learned Counsel for the respondent, that an objection to the application for condonation delay has been filed today
Lordship.
by serving a copy of the same to the Learned Counsel for the appellant. First of, he has submitted that as the said objection is not tagged with the case record, the case be listed after a week. First of, ordered accordingly.
Okay.
List the case after a week on a date to be fixed by the office.
Daily list for admission. Item number 1.
May I please, Lordship? It is a criminal jail appeal, Lordship. Passed by the additional session judge come special judge Mohita, Lordship.
You filed it on 28 August, so it should be under the new law. You filed it in August 2024.
But I-
Heard MSD Borpujari, Learned Legal Aid Counsel for the accused appellant, and MS A. Begum, Learned Additional Public Prosecutor for the respondent number 2, State of Assam. This criminal appeal is directed against a judgment and order dated 25/06/2024, passed by the Court of Learned Additional Sessions Judge, Special Judge, within bracket POXO, Morigaon, within bracket the Special Court. Okay. Offense.
302.
Okay, heard Mr. A. Ahmed, Learned Counsel for the appellants, NMS A. Begum, Learned Additional Public Prosecutor for the respondent state post of. Learned Counsel for the parties have submitted that they have received copies of the paper book, and as the matter is ready, the appeal be listed for hearing. Post of. As the paper book is ready and the Learned Counsel for the parties have received the copies of the same, list the office to list the appeal for hearing.
Last order, it was reflected as a amicus curiae. I am a legal aid counsel, my lord. My lord, they have submitted the paper book. I will file my objection, my lord.
Huh? You are amicus,
No, I am legal aid counsel, my lord.
legal aid counsel for the appellant.
My lord.
What objection you intend to file?
My lord, they have filed in my IA, they have filed paper book. Submitted.
There is no, they have filed objection. Paper book is ready.
My lord, then I can move my
Your IA is for suspension of sentence.
sentence.
Public prosecutor has submitted an objection. Plus paperwork is ready. So you are, there is no scope for filing another.
Next statement.
Huh?
My lord, time may even.
No, see, paperwork is ready, no point. If the IA is also ready, paperwork is ready, so case is ready for hearing
My lord,
otherwise.
it will fix for hearing, my lord.
Are you pressing this IA?
My lord. Yes.
No, which one is pressing? You are pressing the IA or pressing the appeal?
IA first, my lord.
Okay.
I is not available with me.
Not available with that.
Actually, I am missing, my lord, because they have taken from me, but not returned.
Huh?
So I.
That is an MS Begum, some allegation against you.
Against me, Lordship, as Jahan,
Huh?
as Jahan have taken, Lordship.
So paper book is available.
A paper book is there.
Yes.
Well, 2 weeks time I given. I will collect the ayat, then I will move.
See, paper book is ready. We can fix it for hearing.
Yes, my lord.
If you praise for the ayat, let us see. English? Huh?
8 witnesses are there, Lordship. 302.
302
From Bokhanto.
for life. He is behind the bar since, my lord, from
See,
March 2023. 9/3/2023.
Don't have any extra copy, which is
No, my lord,
extra copy of the I. You don't
Yes.
have.
paper book আছে
I don't have.
paper book আছে ayat কি reading
Yes, I-
abilities
Objection to disability.
My paper book.
Only paper book. Objection for one. Oh, then I can give her the objection we have.
no whatever
Copy of objection only.
The objection we have filed, she have not received, Lordship.
I have not received.
that is when paper book is ready. So what is the purpose of IA or objection? Straight away you can make submission from the paper book whether you have really some merit for suspension of sentence. Have you got the idea?
My lord.
কি আছে এটা আছে এটা ফর্মালিটি হে
Objection to the file.
এটা কোন আপনি কোন সামনে কি কোনেও না চাই কোনেও না চাই পেপার বুক যদি রেডি থাকে মানে এগুলো কি এগুলো কি ঠিক আছে এগুলো এগুলো ইনভেস্ট করি আমার কাজগুলো নয়
এখন মই প্ৰমাণ দিওঁ, এখন মই দিয়াই দিম।
এলিস লাইভ আবার চল দিয়ে দলে ভাবিব লাগিব Yes, is it a case of circumstantial evidence or direct evidence?
My lord, circumstantial, because nobody have seen in
Let us see the FIR.
my lord. Effusion,
Page number 4.
Is to inform you that 28/2017 internal so I have got information
4.
from Bokhanto Gogoi Garden Chokida that one of our Chokida, Dilip Das, has been injured by Padal Mura, civil with a town. FIR was lost on the basis of information.
information, my lord. And my
Now,
lord,
where Mr. Bokhanto Gogoi?
Bokhanto
Bokhanto Gogoi deposed. Eyewitness, direct eyewitness.
Bokhanto ready করেছিল।
So that I played shouting. After I crossed some distance, local people came out. I told them about relief for this. Reach they're having blood. Asked about the matter. Why for relief team? Their foreigners on there. We told them about the matter. Delhi was sent by us. We informed manager. Dilip died. Used to work as that your right. You still. I saw the weapon of assault, which is in Magadha. Hard. When I shouted all hard. The cut was on me, and so it's true. Who is the postmortem doctor? Postmortem doctor,
JPW 8 logic, page number
PW8.
22.
Male body during examination. One deep incised wound over right lower part of the neck. Right lower part of the neck. One deep incised wound on right elbow joint. Exactly consistent with the
The evidence.
with PW2 testimony.
He has not explained the scene, my lord. He has stated that I saw the weapon of assault.
No, firstly you read page 11,
My lord,
first line.
I saw that I saw that after I crossed some distance. Come out, I told that about.
You did not dispute that PW2 was not with the disease. See your cross-examination.
I saw the weapon of the assault, which was a Nagada.
No, go down. What did it look at? Come out, and I saw it all of them. What was in the power?
PW3 is res decia.
Second name is that is me and Dilip asked him to speak.
Res decia, I asked him
On his name.
Me and.
immediately after.
Not still-
He was alive. Dying declaration.
I saw that. With hearing.
PW4 no, however.
Only one witness stated that he has seen the.
Sole eyewitness, if he inspires the confidence of the learned trial court.
But Dow was not.
Also, Dilip Gana. Yes, PW6 and I saw the accused running away.
Just saw the running.
Direct evidence, rule 6 evidence, section 6 evidence, section 8 evidence. Post. Exactly tell you it. PW2, we are considering your IA, not the main appeal. PW2, direct evidence, not discredited. Prima facie. PW3, her testimony is admissible under Rule 6 as a res decia.
Seal.
Then PW6, the shopkeeper.
Business.
6, yes, Rahul Day. His evidence is also clear. He saw Dilip
The house of.
coming down the hillock with injuries, and he saw injuries on hand and chest. Then he saw accused running away. Post-occurrence conduct in the course of same transaction. And exactly tallies with their testimony is telling with
Doctor.
PW7. You argue the appeal.
No.
We are closing this. You need time?
My lord.
Okay, day after tomorrow. Come prepared.
We have to go to holiday.
Uh-huh.
It's a 5.
Holiday,
Wednesday.
Thursday. Hard. MS,
M. Das.
M. Das, Learned Legal Aid Counsel for the applicant appellant.
Apple.
And MS Jahan, Learned Additional Public Prosecutor for the opposite party state. Full stop. MS Das Learned Amicus Curiae has submitted that the case be listed on Thursday to enable her to make submission on the basis of the materials available in the paper book poster as read for. Place the case on Thursday.
5-9.
As on.
Begum. Oh, A Begum. I have said Yazdan. A Begum.
Big problem.
Because she said some.
Esther has taken her. I.
Item 7.
Huh? To be present for hearing an application. Keep up with written, no? MS Begum, is this the format? I don't know. Please apprise us. And who is this lady?
That is the lordship. Sanjana Setri was the informal lordship. Paragraph 3 lordship.
Paragraph 3, but judgment says, come to page, judgment first. First page. Facts of the case. The prosecution case in a nutshell is that on so and so, the complainant Shibu Sharma lost the FIR. Shibu Sharma is brother. Come to page, running page 92. Running page 92. PW 9. Shibu Sharma. And his description is brother of Shibu Sharma.
Younger sister.
Hey, LC Anderson. Who never to defeat this? It will do prosecutrix. Oh, এক number. PW1. Prosecutrix will have it. নাম লিখে ঘোরা আছে এতিয়া কথা হল ইয়াতে থাকিব
একটু হবে না এবার কি করছে Lordship, I'll inquire. Lordship.
No, this is lordship, instant case, I'm sorry.
Yeah, I think it's.
Page 1, FIR number 85. To ekon photo bisa niki. Oh, this is different case, your lordship. Because FIR number is 48, here FIR is 85.
and I will not disclose the name, but this name is different from the prosecutrix.
Lordship,
So, belek case.
they have given some other.
So 10 minutes gone.
That also sent by WhatsApp, Lordship, I have.
Mr.
DFA Ahmed. lordship.
JFA Ahmed.
DFA Ahmed on behalf of
D
Jail.
for Delhi.
Delhi.
DFA Ahmed, Learned Counsel, representing Mr. J. Losco.
Jail.
Learned Counsel for the appellant and MS A. Begum, Learned Additional Public Prosecutor for the respondent number 1, state. MS Begum, Learned Additional Public Prosecutor has sought further 2 weeks time to obtain a report as regards service of notice upon the respondent number 2 and the respondent number 3 from the officer in charge, Half-Long Police Station. Who is respondent number 3?
It is from Haflong only, but this one.
Respondent number 3 is, the name is reflected there. Name is reflected. That is the informant. That is the prosecutrix. And PW2, brother of the prosecutrix and the informant. Place the case after 2 weeks.
Item 8.
Lordship, I am told they are pressing for the IA, but no objection has been filed by us. Lordship, 10 days time be granted. Service is complete in this case.
Also,
Also.
yes, S. Mitra, learned counsel for the appellant in 11. And MS B. Bhuiyan, learned senior counsel and additional public prosecutor for the respondent state are present. You have received,
Yes,
Lordship.
learned counsel for the parties have submitted that they have already received the copy of the paper book. First off, as the paper book is ready, office to list the appeals for hearing in due course.
Obliged, Lordship. Items 13 and 14.
Office will list, it is, I have seen the period 1 year detention. People are 7, 8 years like standing in a queue. So in the usual course,
13 and 14.
no tatkal seva. Yes,
Before he starts, no copies are on us.
no copies are.
No
Very
copies-
serious allegation.
File
No,
objection.
that IA copy we have already served.
I don't know.
Yes, yeah, after serving.
I'm not
only
saying that
accept- the Lordship.
Allegation is leveled. I've
Yes,
said
that-
allegation. Allegation may not be true.
Yes,
Yes.
that can be verified from the record itself because office signature is there. Otherwise, they do not accept our filing. Lordship.
Okay, whatever. This has come for what?
The suspension of sentence and grant of bail. Lordship.
Oh, objection file.
Objection filed. Even objection also filed.
Who has
Huh?
filed?
They have said.
No, no, I just saw who has filed. I have not received any copy.
Objection filed.
Who has filed? Last order to what?
But here no objection filed. Office note says no objection filed.
Filed by whom?
Find out. No, if objection is filed, then it is ready.
Yes, there are two cases. They have filed in respect of one cases only.
Who has filed this?
Which one? The 13. Paper book under preparation. Itu gimana? Itu 466.
দুইটা দিব এই ইমরানৰ আছিলে
যোৱা বছৰ কিমান কিপিং এপিল ৰেজিষ্টাৰ হৈছে? যোৱা বছৰ কিমান হৈছে? Idea. 466 বহুত বেছি লাগিছে। Just more only হৈছে ইমান ৰেজিষ্টাৰ নহয়। নহলে পেজটো বঢ়াব লাগিব disposal।
All objection complied on status.
অবশ্যই সিঙ্গেল বেঞ্চ আছে। In the IA 32 file,
IA 32.
here in this IA 27, I don't think objection has been filed.
In this case, not filed. In one case, they have.
Probably Miss S.H. Bora has filed objection in
In
other
item
matter.
32,
Yes, fine.
IA 32.
Lordship. So
But in IA,
take a copy from him and other matter I'll file my objection.
Mr. Ahmed, since you are private counsel, furnish one more copy too.
I'll get
Yes,
the Xerox
Lordship,
memo.
just now I have been informed that they have taken the copy of the objection and that was not returned to us.
Who has taken?
Just-
Same MS
Who has
Bora
taken?
has made.
Only date is mentioned here.
It's mentioned. Who has taken? Jahan Bhai. I may not be made responsible for.
No, আপনি
It was filed on 1/6.
So how to come out of the situation?
I'll get it Xerox, then.
No, they don't have. You have original copy, no. They don't have original copy.
Lordship, if your lordship. are-
And I'll permit heard Mr. H.R.S. Chaudhary, learned senior counsel assisted by Mr. Yamit, learned counsel for the applicant appellant. M.S. B. Bhuiya, learned senior counsel and additional public prosecutor for the opposite party number 1, state assisted by Ms. M. Chakraborty, learned counsel. And who is for opposite party number 2?
One
Full stop.
Mr. MS.
Ah. Learned counsel for the parties have submitted that.
This one,
And MS?
MS A Begum.
A. Begum. You don't have also a copy of the IA? Huh?
Actually, Mr. MS is in the case.
Do you have the copy of the IA? Huh?
We supplied, madam. We have taken step, they entered appearance.
All have misplaced.
But that is another aspect, man. But as a result,
Uh,
suffering.
MS?
Yes,
You
ma'am.
लिख ले?
A Begum.
A Begum.
Learned counsel for the opposite party number 2. Full stop. ইমান ডাঙৰ আহি এইখন কিমান এইখন নেকি আহি
বনালে তুমি তো যদি আমি করে দিই না, আমি দিব না। গভর্নমেন্ট প্রবলেম আছে ভালো সার্ভিস আমি দিব না।
Mr. Amit, you can furnish a copy of the judgment.
I will find the copy of IAS.
You have the copy.
Interlocutory application is there, but the copy of the objection they have taken on the earlier application, that is not with us.
Or that one,
The lot.
in the other one.
Yeah, that-
From the
Copy of
judgment
the
only I can, since we have formality has been done, my lord. So from the judgment, I'll make my submission.
Or if objection is in the file, my
Copy of
lord.
the I-
If it is
No, no.
the file, we have a copy and. that-
Do you have, can you, Mr. Amit, can you furnish to MS Bhuiya copy of the IA in 27?
No, already taken from them.
Already just now.
Other matter, item 14.
No, no,
my-
please, one by one.
No, I have already taken.
Please,
copy.
I'm not very expert in assimilating things. I am in item 13 only.
13, I have already taken copy from.
You have received.
Just.
Now I can say that you'll
Just
file
now.
objection.
Yes.
And in the other one,
And
item
since
14,
They do not. have-
objection has been filed.
They don't have the copy. I also don't have the copy. I'll take a copy from.
Yeah,
Yes.
no, this is not permissible. I'll observe in the order.
Uh,
I'll observe in the order to furnish a copy,
my-
right?
That.
Taking out,
Yes, yes, that
It's
now,
not-
that cannot be done.
that should not be encouraged.
Yes, ma'am. That's true one.
Lekhak, MS Bhuiya, who has received a copy of the IA Criminal 27/2024 today, has prayed for and is granted 2 weeks' time to file an objection. Who's the MS? Madam,
A Begum.
do you have any intention to file objection? Writing?
Actually, my lord, Mr. MS is in the case, he is out of station
Okay.
today. That is why I can.
It's up to this,
Para.
my lord.
As Mr. Amit, learned counsel for the applicant. In IA Criminal 32/2024 and MS Bhuiya, learned additional public prosecutor for the opposite party state, have submitted that a copy of the interlocutory application in IA Criminal 32/2024 are not available, is not available with them. Office to furnish a copy each of the interlocutory application to Mr. Amit and to Mr. Oh, sorry, objection,
All the
objection, objection, huh? Objection filed by the state to both Mr. Amit and MS Chakraborty within a period of 1 week.
She also needs a copy, maybe.
Huh? Your objection only.
She said. She's
Oh.
against, yes.
You assist. Oral submission will also do by Mr. Sheikh. Okay. Release the case.
We are having some urgency.
After 2
madam.
weeks, huh?
Some urgencies, subject to your worship, some urgency is there, madam.
2 weeks, 2 weeks. Because she needs time in to file objection in the
Objection
I-27.
already it is there, she can file within 2 days, already it is there, madam. So there is no
1
need of
week,
2
1
weeks,
week.
madam.
1 week.
So date may be fixed.
1
madam.
week, 1 week. No data I am not going to fix.
1 week, madam.
1 week.
After 1 week. Obliged to obliged.
Item 15.
Regarding
Yes, sir.
delay, lordship, there is a office.
No.
16 and 17.
Meet your lordship. Your lordship, this matter pertains to the detention of the Rohingyas, your lordship, who are being illegally detained. Your lordship, even after they have completed their sentences, your lordship, for the last.
Yes,
10
where is Deputy Solicitor General of India or MS? Yes, MS, LDB.
Your lordship, now they have got they have got seen a ray of hope that
Yes.
the Canadian authorities, your lordship, they are willing to do some formalities and grant them refugee status in their country, your lordship. For that, certain formalities has to be observed, your lordship. But since they are in Mathia detention camp, your lordship, an order of this honorable court is required, your lordship.
Some instruction has been received.
Yes, let us see.
Provided.
Now, in the meantime, Canadian laws have been changed drastically.
Yes, your lordship. That's why, your lordship, the UNHCR is hurrying up the issue, your lordship.
You have only one copy.
Thanks.
Bring this instruction on record is not, they are not in favor of. The union is not in favor, that is there, according to them, that is not as per their policy. Some office memorandum has been referred to. Let it be brought on record, their stand in affidavit, otherwise it will be difficult. Then we can see. How do you instruct? That is all, that is specific to this case. And first contention is that India is not a signatory to the 1951 UN Convention relating to status of refugees and 1967 protocol. There are other office memorandums they are referring to. Let it be on record because this is international policy. Because if it is not signatory, India is not bound. This is one application, one petition. I in one, right? I in WPC 3576.
Lordship.
Heard Mr.
I, Hussein.
I. Hussein. Learned counsel for the applicants. Who is that? Mr. Payeng. Because Payeng has some responsibility, I think. And Ms. L. Devi, learned counsel appearing on behalf of Mr. R.K. Dev Chaudhary, Learned Deputy Solicitor General of India, for the respondent number 1. Full stop. The Learned Standing Counsel Home Department for the respondent number 226 is found absent today on call. Full stop. Para MS Devi, Learned Counsel appearing for the respondent number 1, has submitted that instructions from the Union of India has been received by letter number 25022 stroke in Union from the instructions from the Ministry of Home Affairs, Foreigners Division, Government of India, has been received by letter number 25022 stroke 120 stroke 2023 dash F capital F full stop Roman 4 dated 9/8/2024. Post. MS Devi has further submitted that the Ministry of Home Affairs, Foreigners Division, Government of India has already issued an office memorandum of event number on 20/04/2023 in connection with WPC number 3576/2017. Close to. MS Devi has. It's within what time?
4 weeks.
Your lordship, if it can be, your lordship. Your lordship, if it can be filed within 2 weeks, your lordship.
Huh?
If it can be filed within 2 weeks, your lordship.
2 weeks.
3 weeks because it has to come from.
Huh? Everything is there.
Instruction is there, your lordship.
Detail office memorandum you have issued. MS Devi does sought for and is granted 2 weeks time to file reply to the instant application. Post. Release the case after 2 weeks on a date to be fixed by the office. Not where you copy it. Huh? A copy to you.
Lordship, if
A
a date
copy of
can-
the letter number so and so and letter number so office memorandum number so and so placed by MS, submitted by MS Devi, comma, be kept with the case record.
Your lordship, if a date can be fixed, your lordship.
After 2 weeks. Like to mention.
Lordship, we have filed our affidavit in terms of honorable court's order, bringing on record the communication issued by us from the LR.
Regarding that issue, my lord, of absence of PP, my lord.
Oh,
On record,
Both cases, my lord, the affidavit has come. 20 and 21, my lord.
Lordship, matter may be fixed for, it was coming.
paperwork is ready.
Paper book is ready, my lord. Only issue is, my lord, its IA is pending for 2 years, my lord, and in our case, my lord.
No, we will be considering the appeal mainly.
My lord will consider it today.
No, it is not for hearing
Yes.
why it has come. Paperwork is ready, we can post it for hearing. We'll decide the issue regarding that alleged part played by the
Court.
learned trial court,
Well,
both as the prosecutor as
As
well
well
as
as the
the
judge.
judge.
My lord,
If your lordship fixing a short date, lordship, then.
Yes, we are fixing a fixed date
Fixed
out
date.
of the hearing
My
list. Silo. Report affidavit. Come to paper book. Page 49. Page 49. Para 2.
Okay.
Affidavit. What does the affidavit reflect?
Lordship, the communication issued from the district judge.
No, what does affidavit sum and substance?
Common substance, Lordship, why that explanation was not from the person concerned, the advocate concerned, why he did not appear. He has replied, and your Lordship, report was also called from the district judge. So his report is also there.
And what is there?
There, your Lordship.
During the trial,
Reason
Huh?
because of the
or
some
during the
discrepancy.
trial,
Yes,
whether from the affidavit, it is evident that during the
he
trial,
was not there.
and more particularly during the recording of deposition of prosecution witnesses,
Lordship.
there was absence of public
Yes.
prosecutor.
Yes.
It is reflected.
Yes, my lord, because of the differences with the learned district judge at the very period of time. So he lodged a complaint and he lordship given a reason as to why he did not.
He did not participate in the trial.
Right,
So we need that only.
lordship.
He tendered his resignation and he did not even draw any bills for that relevant period, my lord. Those are there, my.
So from the affidavit, it is clear.
Yes, well, as far as the affidavit is concerned, it has come in respect of item number 21, but the period remains the same because the periods overlap, my lord. And in our case, my lord, the records also very specifically demonstrate that he was absent from the date of framing of charge till the date of judgment, my lord. Every order.
Communications were sought for in only as regards one item number 20. So lordship on the last occasion directed us.
So
to
in the
look for
other
record.
case, it is not reflected in the judgment.
Yes,
ma'am.
so it's in terms of honorable court's order, I have also filed an affidavit in the other case also.
What is the session case in other one?
Mr. Ahmed's case, my lord, will be sessions case.
Because, see, Mr. Nawaz
My lord.
or Mr. Ahmed, some drastic order might result.
My lord.
Some drastic order might result. So we need all these materials
On record.
on record so that this type of things do not recur. Also, not only in your case, but in other cases. As you have submitted that there may be other cases
Other cases,
also
because that entire. period-
emanating from that particular district
Madam.
during that period. Yes, Mr. Ahmed, in your case, specific documents are there.
Lordship, they have filed their affidavit and it is clearly shows that the PP was absent during that period, Lordship.
This is sessions case. What is your sessions case number?
08 of 2021.
2021,
08 is yours.
Lordship,
Yes.
my case.
And your
My case, my lord, is sessions.
no, special
Special
POXO
case
case
POXO
number
case.
05 only 2020.
Because my lord, no report as such specific to our case
Yes.
was called for, because the records itself were made it very evident that he was not there. In Mr. Azad's case, my lord, that was not there. So that is why report was called for.
That they have filed their affidavit in connection with.
But they have filed affidavit in both cases.
yes, MS Bhuiya, that facts which happened during a trial in respect of the POXO case. Can be noticed so far as sessions case number 8 of 2021. It is clear
Yes,
from Annexure A,
yes,
right?
yes.
My lord kindly has page 138 of the affidavit, my lord. Hmm. In- Hmm. Hmm.
Then everything will be clear. Whether that man has power or not, that is a different issue. But he has devoured. I don't know he has power or not. That is doubtful. Public prosecutor is not subordinate to, or not the appointing authority also. Things are coming to light. Serious matters are coming to light. Have you read
Lordship.
paragraph 14?
Yes, my lord. So should we bring or the raise to be directed, my lord,
Huh?
to bring it on
No,
record?
we are in criminal appeal.
Lordship. So we'll make an endeavor.
We are not
to-
dealing with petitions.
My lord, lordship. So lordship I'll make an endeavor to call for this.
Get it on
document.
record.
My lord,
First, being it on record.
my lord.
This will be available, and that it will clinch. And secondly, he was also the special public prosecutor or not
My lord.
for his case. If there is only power, he was the only public prosecutor, because state government shall by notification in the official gazette appoint a special public
Special.
prosecutor. If district judge is the special court, but still there has to be a public prosecutor, special public prosecutor for conducting POCSO cases.
Trial, my lord. The POCSO trial.
The appellant, MS B. Bhuiyan. Yes, MS Devi, would you like to highlight anything? Learned MS B. Bhuiyan, learned senior counsel and additional public prosecutor for the respondent number 1, State of Assam, semicolon, and MS L. Devi, learned legal aid counsel for the respondent number 2. Full stop. MS Bhuiyan, learned senior counsel and additional public prosecutor, has submitted that an affidavit regarding the state of affairs in District Chirang during the relevant period as regards the office of the public prosecutor has been filed. Full stop. Para. In this criminal appeal, the issue is regarding trial of an offense under a special act, Protection of Children from Sexual Offences Act 2012. Full stop. The judgment and order, a judgment and order dated 24/8/2022, passed in special POCSO case number 05 of 2022, is under challenge. Full stop. Para. From the it has been submitted at the bar that the learned public prosecutor appointed for the district of
Chirang
used to conduct
used to conduct
the cases, trials before the learned special court in respect of cases under the POCSO Act 2012 during the relevant period of time. Full stop. Para. It transfers it further transfers that an order under memo number page paragraph 14 number 2 under memo number DJCH Silo point Roman 5-10/2020-2021 /2185 dated Kajalgaon 2309 2020 was passed by the then District and Session Judge Sirang, whereby the public prosecutor was debarred from conducting the sessions cases which uh, which also included cases under the POCSO
POCSO
Act
Act.
2012. So
Do the
so that we can go for hearing. I think it is
On 13 is
Ten.
Friday.
13?
12.
13?
13 is.
11 or 13?
Lordship on 13.
13. Place the case on 13.
Unless we'll keep it as part heard.
I don't know whether I'll continue.
Because the
Not-
lordships have substantially heard this issue. That's why
No, we are not substaining. You'll be addressing what kind of prejudice is caused. Both have to address. We are completing the materials. We are in the process of completing the materials. Then we'll start hearing. Paper book is ready, we'll start hearing. Just come with all preparation. What are the prejudices suffered by the appellant or by the state? MS Bhuiyan?
My lord.
will this come up for hearing or what is?
No, 13, let's complete, then definitely within next day we'll start.
My lord.
The whole thing.
I'm deeply obliged, madam.
We'll start dictating that partner matter.
Second of my.
We'll dictate and judgment.
My lord, that's
First.
why, so item 19 may be taken on fifth, my lord, if possible. It will come for hearing, my lord. Last time your lordship was pleased
Keep
to.
somebody here. Keep somebody here, we'll accommodate according.
I may not be there. that's-
18, okay. No issue. Somebody, Mr.
Well, anybody, somebody will.
Ayush Chaudhary or Mr. Ahmed
I will.
or any of your associates,
Some of
we'll
the
accommodate,
Chaud-
we'll
some of the
accommodate.
Chaudhary will be there. Any of us.
And 18,
18, we are paying for the
State.
state lordship. Probably the paper book would be required, my lord.
we'll
Maybe
see.
like a secretary.
PS 2010,
LCR is there, but lordship.
it was, earlier it was listed before one single judge.
but what state appeal?
State appeal.
Instead of.
Paper
Then
book.
after that, it was ordered by another single.
The year 2010 is staring at our face.
I've gone through my record, my lord, it is all vernacular. Vernacular, my lord, some of them are not totally illegible. So, my lord.
We'll find out from at 2.
On hearing,
18 song. 18 to song. LCR to song. But that was so Joseph. How many witnesses? PWs?
9.
What's the matter? Huh? Nine. Original case Sunarba. 2006. Original case 2006. Incident is of 1998.
2008, my lord.
1998,
Yes, my lord, yes.
26 years. Fine, hello. Some are in English, some are in Bengali. People বানাবো এটা। Hmm. Heard MS B. Mia Garnett, Senior Counsel and Additional Public Prosecutor for the appellant, State of Assam, and Mr. FKR Anand,
12341,
Learned Counsel for the respondent number 124.
234,
1234.
34.
124. Full stop. The instant criminal appeal is preferred by the respondent appellant state under section 378 Code of Criminal Procedure 1973 against a judgment an order dated 17/4/2008 passed by the Court of Learned Additional Session Judge FTC Karimganj in Sessions case number 72 of 2006, whereby the respondent number 124, who stood in the trial as accused number 124, were acquitted by the Learned Trial Court. Trial court করিব। Full stop. Para. The appeal stood transmitted. The appeal has been placed before the division bench pursuant to an order dated 3/10/2023 passed by the Learned single judge. As a criminal appeal is still then, was pending before the Learned single judge. Where Learned Counsel for the parties have submitted that the paper book is to be made ready, for the purpose of hearing the appeal. Full stop. As the alleged incident involved in Sessions case number 72 of 2006
Yes.
had allegedly occurred or had occurred on 31/3/1998 in the period of more than 26 years have elapsed in the meantime, the office, the registry used to prepare the paper book in an expeditious manner. Also, it is therefore directed that the registry shall take steps for preparation of paper book as expeditiously as possible. Post of release the case after 4 weeks. Release the appeal after 4 weeks. For a report on the paper book.
Right. Good.
Item 22.
Item 22. Parted. Lagi di 5 minit lagi mo suami. Okay. It is a settled proposition that the circumstance of laughing together is a facet in a case based on circumstantial evidence. Full stop. The circumstance of last seen together is ordinarily taken into consideration for finding an accused guilty of the offense charged with when it is established by the prosecution that the time gap between the point of time when the accused and the deceased were found together alive and when the disease was found dead is so small that the possibility of any other person being with the deceased can be completely ruled out. Full stop. The time gap between the accused person seen in the company of the deceased and the death of the deceased would then be a material consideration for appreciation of the evidence and to place reliance on it as a circumstance against the accused. Full stop. It is true that it cannot be said that the evidence of last seen together is to be rejected merely because the time gap between the accused and the deceased last seen together and the death of the deceased came to light after a considerable possibility is to be rejected merely. Is to be rejected only because the time gap between the accused person and the deceased last seen together and the date of the deceased was found out after a considerable period of time. Full stop. There can be no fixed formula for the duration of time gap, and it depends upon the evidence laid by the prosecution to remove the possibility of any other person meeting the deceased in the intervening period. Full stop. In other words, comma, if the prosecution is able to lead credible and convincing evidence that likelihood of any person other than the accused, comma, being the author of the crime, comma, becomes impossible, comma, then the evidence of circumstance of last seen together, comma, despite a long time gap, comma, can be considered as one of the circumstances in the chain of circumstances to prove the guilt against such an accused person. Full stop. Para. And does, comma, for the to bring in the applicability of last seen together theory in a case based on circumstantial evidence, comma, there is the burden, the prosecution is cast with an obligation to prove two facts by reliable and credible evidence, comma, firstly, comma, when the accused and the deceased were last seen together with the deceased being alive, semicolon, and secondly, when the deceased had suffered death, had suffered unnatural death. Full stop. Para. At this juncture, comma, we can turn to the testimony of the autopsy doctor who was examined as PW7 and the postmortem examination report, which was exhibited by the prosecution as EXT2. Full stop. From the postmortem examined PME report, EXT2, it is revealed that the postmortem examination on the dead body of the deceased was performed at Udalguri Civil Hospital on 21/11/2011. Full stop. In his testimony, Dr. Orindam Bora deposed that the 511 also, okay? 21 no, 21/11 511. Deposed that on 5/11/2011, he was working as the medical and health officer 1 at Udalguri Civil Hospital. Full stop. It was on 5/11/2011, he performed post-mortem examination on the dead body of Uma Paul, who was identified by UBC, Purnima Boro. Full stop. On examination, he, PW7, found the dead body as a decomposed one with maggots, MAGGOTS. Full stop. In the PME report, he recorded the following findings. PW 52, 50, page 52, here's 52, A2. A2A. In the PME report, PW7 further stated that in the PME report EXT2, he recorded his opinion and as per his opinion, the death was due to asphyxia following strangulation. Full stop. PW7 exhibited the postmortem report and his signature therein as EXT21. Full stop. In cross-examination, PW7 reiterated that the dead body was a totally decomposed one, and the muscles were found separated from bone. Full stop. He denied the suggestion that the death was I don't know how no, it is. Not to আমি নিজে হওয়া পারিম জানো not to আমি নিজে হওয়া পারিম জানো এই যে পেজ for 24. Hmm. Hmm. Ah. Hmm. Testified he further testified that he could not detect whether C2 fracture was antemortem or not. Post. Para. Para nalage, para. From the testimony of from the evidence of the investigating officer, Munindra Basumatari, PW6. Hmm? From the affair, from the contents of the affair, EXT1. No, at the time of institution of the affair, EXT1 on 4/11/2011, the dead body of the deceased, Umapal, from the the dead body of the deceased, Umapal was not recovered. At the time of institution of the affair on 4/11/2011. Considering the fact that the postmortem neither any of the prosecution witnesses, including the IO, PW6, did not specifically mention as to when the dead body of the deceased was recovered. Full stop. However, considering the fact that postmortem examination of the dead body of the deceased was performed on 5/11/2011, it can be safely concluded that sorry. Considering the fact that considering in the PME report PXC2, it was recorded that the dead body of the disease was dispatched at 1 p.m. on 5/11/2011, and it was received at Udalguri Civil Hospital at 1:20 p.m. on 5/11/2011. Full stop. From the above, materials, it can be safely concluded that the dead body of the deceased was recovered in between 6 p.m. on 4/11/2011, when the FIR was lost, and 1 p.m. on 5/11/2011, when the dead body was dispatched. Full stop. The prosecution has not laid any evidence as to when the deceased met her death. Full stop. The medical evidence in the forms of the testimony of the autopsy Dr. PW7 and the PME report EXT 2 do not throw any light as regards the time and date of death of the deceased, even by approximation. Full stop. Thus, it is not possible, though it is possible to though from the evidence to materials from record, it is possible to it is established about the time period when the dead body of the deceased was recovered, but it is not possible to reach any conclusion as regards the time and date, as regards the time and date of unnatural, alleged unnatural death of the deceased. Full stop. Para. The prosecution witnesses this PW1, PW2, PW3, PW4, and PW5 did not specifically depose as to when the deceased had gone out of her house at village Alisinga police station Dhekejoli for Orang ওৰাঙতো এটা বেলেগ পুলিচ ষ্টেচন, ওৰাং পুলিচ ষ্টেচন আছে। Orang is there is police station. Orang police station, which is under territorial jurisdiction of Orang police station, purportedly for medical treatment. Full stop. These prosecution witnesses did not depose to the effect that it was the accused who had accompanied the deceased during her journey from village Alisinga to Orang. Full stop. There is no evidence stroke materials on record to the effect that the disease was last seen alive in the company of the accused. Full stop. Para, in the above obtaining, in the above facts and circumstances obtaining the case, we are not persuaded to reach a view that the prosecution has been able to bring in the applicability of last seen together theory by any manner. Full stop. In view of failure on the part of the prosecution to bring in the theory of last seen together alive, it cannot be said that correspondingly, the honors had shifted to the accused to provide a plausible explanation in terms of Section 106 of the Evidence Act. Full stop. In this connection, The following observations made in Sarad, Bedis and Sarda can be appropriately referred to paragraph 159 and paragraph 130 or 160. Post. It has been urged on behalf of the prosecution that recovery of the dead body of the deceased was made at the instance on after being pointed out, after the place was pointed out by the accused. Full stop. Reference is made to the testimony of the IO PW6 in that connection. Full stop. Para. No, full stop. In order to examine such contention, comma, the evidence given by the IO of PW6 a discussion of the evidence given by the so-and-so appears necessary. Full stop. But as per the testimony of IO PW6, comma, the FIR was received by the officer in charge, Urang Police Station, at around 6 p.m. on 4/11/2011. Full stop. The accused was handed over by the informant PW 1 at Thekiazuli Police Station, wherefrom the accused was brought to Urang Police Station. Full stop. PW6 further stated that the dead body was recovered after the same was shown by the accused. Full stop. PW6 did not exhibit any sketch map as regards the place and the time, as regards the place wherefrom the dead body of the deceased was recovered. Full stop. He only stated that the dead body was found laid on the ground, comma, covered with branches and leaves of tree. Full stop. PW6 stated that he did not seize anything from the PO, within bracket, the place of recovery of the dead body. Full stop. PW6 also admitted that no one is examined at the time of recovery of the dead body, as he found on the pretext that there was no habitation near the PO. Full stop. Though PW6 stated that inquest was held at the PO itself, he did not, however, exhibit the inquest report. Full stop. PW6 also admitted that there was no witness to the inquest. Full stop. PW6 further deposed that when Durgapal, no, further deposed that Durgapal, PW3, stated to him that when he, within bracket PW3, asked the accused in threatening language, comma, the accused confessed his guilt. Full stop. কন্ডিশন যেটা করেছিল এই যে রিকভারি এটা যে 27 এখন চাইছিল না একবার এইটো memorandum এইটো 25-26 এইটোত আছে নাই Para. As per section 25 of the Evidence Act, a confession made to a police officer shall not be proved as against a person accused of an offense. Full stop. Section 26 of the Evidence Act has provided that no confession made by any person while he is in the custody of a police officer, unless it be made in immediate presence of a magistrate, shall be proved as against such person. Full stop. Section 27 of the Evidence Act is an exception to Section 25 and Section 26 of the Evidence Act. Full stop. It makes that part of the statement which distinctly leads to discovery of a fact in consequence of information received from a person accused of an offense, in the custody of a police officer, to the extent it distinctly relates to the fact thereby discovered, admissible in evidence against the accused. Full stop. The fact which is discovered as a consequence of the information given is admissible in evidence. Full stop. Thus, what is admissible being the information, the same has to be proved. And not the opinion formed on it by the police officer. Full stop. To bring in the exception, the exact information given by the accused while in the custody, which led to the recovery, has to be proved. It is necessary for the benefit of both the accused and the prosecution. It is settled that it is necessary for the benefit of both the accused and the prosecution that the information given should be recorded and proved. And if not so recorded, the exact information must be adduced through evidence. Full stop. In the case in hand, only the IO PW6 had deposed to the effect that the dead body of the disease was recovered after being shown, after the place was shown by the accused. First off, the fundamental infirmity in the present case is that the exact statement said to have been made by the accused, which ultimately led to the discovery of a fact to be relevant under Section 27 of the Evidence Act, was not brought on record. Full stop. The full stop. The dead body. Full stop. The prosecution has not had not laid any evidence that at the time of discovery of the recovery of the dead body, there was any witness or not. As no memorandum was prepared, was found to have been prepared in that connection. Full stop. In absence of any evidence as regards the information given by the accused leading to discovery of a fact, we are not persuaded to agree with the submission advanced on behalf of the state that the recovery of the dead body of the deceased would be admissible under the rule of evidence embodied in Section 27 of the Evidence Act. Full stop. Section 8 আহিব নেকি? Section 8 আহিব নেকি? with no witness deposing regarding recovery of the dead body, 7, except the IO, PW6. And no evidence regarding the accused accompanying the IOPW6 at the time of recovery of the dead body, the recovery of the dead body cannot be brought cannot also be brought within the purview of Section 8 of the Evidence Act. Subsequent contact nahi. It cannot be brought. Close to. Which no substantive, with no direct evidence. On the point of seeing the deceased, seeing the accused in the company of the deceased, with the deceased seen alive, semicolon. Due to non-applicability due to absence of any evidence as regards the time and date of the deceased, even by approximation, semicolon. Non-applicability of the theory of last seen together, semicolon. Doubtful nature of evidence as regards recovery of the dead body. Comma. There is no substantive evidence as regards, and there appears to be no substantive evidence as other than the alleged extrajudicial confession made by the accused before the prosecution witnesses mentioned above. Full stop. While an extrajudicial itself is considered to be a weak piece of evidence, acceptability of any extrajudicial confession, to accept any extrajudicial confession, it has to inspire the confidence of the court. Full stop. The circumstances in which the alleged extrajudicial confession was shown to be made, the same has not inspired the confidence of the court. Full stop. In the light of the discussion made above, from the discussion made above, from the discussion on the evidence stock materials on record, we find that the various links in the chain of evidence laid by the prosecution have not been satisfactorily established. Pointing to the guilt of the accused with any kind of definiteness and in proximity to the time and duration. Full stop. It is true that there is it is true that there is in view of the nature of relationship that existed between the accused and the deceased, the needle of suspicion can be pointed towards the accused. Full stop. But it is settled that suspicion, however grave it may be, cannot take the place of proof. And there is a large difference between something that quote unquote may be proved and something quote unquote may be true and quote unquote must be true. Full stop. In a criminal trial, suspicion, no matter however how strong, cannot and must not be permitted to take the place of proof. Full stop. The large distance between may be true and must be true must be covered by clear, reliable, credible and unimpeachable evidence. Before an accused can be held guilty, Full stop. It is also a fundamental principle of criminal jurisprudence that if two views are possible on the evidence adduced in a case, comma, one pointing to the guilt of the accused, another to his innocence, comma, the view which is favorable to the accused is to be adopted. Full stop. This principle has a special this principle has assumes relevance and pertinence in cases wherein the guilt of the accused is sought to be established by circumstantial evidence. Full stop. For the reasons mentioned herein, comma, we are in disagreement with the finding of guilt arrived by the learned trial court on the evidence stroke materials on record, comma, discussed herein above. Full stop. Holding that the prosecution had failed to prove the case against the accused. Your conviction. Okay. Conviction is under
201.
120B.
120 be gone. 120 not 120B is gone. 2021. এখানে লিখা হয় বটে, হ্যাঁ? Para. The offense defined in section 201 from IPC is attracted when one causes disappearance of evidence of offense or gives false information to screen the offender. Full stop. The essential ingredients of the offense under section 201 IPC are: one, firstly, comma, an offense has been committed, semicolon. Secondly, the accused knew or had reason to believe that such offense had been committed. Thirdly, the accused caused disappearance of the evidence thereof, semicolon. Fourthly, the accused gives false information in respect thereof, semicolon. 50, knowing or having reason to believe the same to be false, semicolon. And lastly, 60, the accused did so with intention to screen the offender from legal punishments. Full stop. When the evidence stroke materials available on record are examined vis-a-vis the ingredients of the offense defined under section 201 IPC, we find lack of sufficient evidence stroke materials to attract the said offense against the accused. It was persuaded disagreement, holding that the prosecution had failed to prove its case beyond all reasonable doubts against the accused beyond all reasonable doubts by way of like credible, reliable evidence. It has a question over. The judgment and order dated 22/12/2017 of conviction and sentence passed by the learned trial court is found unsustainable in law and is liable to be set aside. Full stop. It is accordingly set aside. Full stop. Consequently, the instant criminal appeal stands allowed. Accused liberty to settle liberty. Trial court record. So and so. Appreciation, M. Dr. Amicus. Any direction regarding
He will be
compensation?
required, Your Lordship. He was the husband, she expired.
Oh.
No
No
children.
issue.
No issue.
You're not entitled.
No,
Lordship, regarding wrong sending of the case diary in the file.
Para trial court record to asli je tara last line or agot penalty paragraph. During the course of the hearing, comma, it came to the notice. It came to notice that the case diary of Paneri Police Station, case number 150 of 2007 under sections 341/376, Indian Penal Code is tagged with the case records of sessions case number 25 within bracket D-U bracket close of 2012. Full stop. Case record send back or piece of the last paragraph. The Court of Sessions, Udalguri, shall look into the said aspect for taking necessary steps. Last paragraph. হেৰি কৈছিল ন ইচ্ছাৰে চৌধুৰী কৈছিল একমডেট কৰিব গৈছিল কোনটো আছিল বা এইটো চাৰ্ডাটো দি দিব এই চাৰ্ডাটো দিব
Item number 19. Okay.
Yes, but some request was made by Mr. Chaudhary. By pasta ke liye fix koi thoi na 50 is not possible. 50 is not possible. We have already fixed
I know.
Okay.
2 items, 2 appeals. Maybe.
Oxo active involvement 376.
76.
Next week.
Next week.
Any date?
Bench. Lordship. Next, yes. Lordship. Any other bench? Lordship. Come to Kojo.
Judgment page 53. Page 50, page 53.
19.
Oh, that. Consecutive sentence. Lordship. Well,
J.M. Sulaiman.
one of them.
You should. Legally. Obliged.
Obliged.